So we were talking about this Government of India Act 1935, and this we told you it's some provisions. This we told also about its significance. This so significance is related to, as we told about, Schedule 7. This so it has influenced Constitution. This which we'll talk when we'll take Constitution. There we'll talk it positive and negative way. Because once a question was asked related to this, so since Constitution, then we'll talk Constitution and sources of Constitution. Sources of Constitution, and then we talk about whether it is a borrowed Constitution. So there it will come as relevance. So historical, if you say the developments are historical underpinnings. So in summary, we can say that it established a centralized system of administration, a centralized system of polity, you can say, and we had some, let's say, the aspects of experience, not, let's say, quite substantial. Some aspects of experience of running a democratic government since 1920s, which was also not very, let's say, that significant, simply because we had civil disobedience movement, Quit India movement. So the leaders were demanding freedom, demanding complete freedom. Hence, even if governments were formed, elected governments were formed, but they did not work properly, because the challenges or developments were more related to adopting complete independence or demanding complete independence. But they went on setting a system of polity. That is the past legacy, you can say. Yes. So, which when Constitution they were framing, they try to incorporate those important features which can be considered suitable for our country, or we cannot completely dissociate ourselves from past. The present cannot be completely dissociated from past, even if it is a British legacy. Yes. And because of that, we can consider. And that is how we'll summarize in 2-3 lines. So then we'll talk next. Let's write on this. The historical underpinnings. The historical underpinnings for Indian polity can be summarized as first, a foundation for centralized polity and administration. Centralized polity and administration. Next, laying down a structure of polity. Next, taking steps to decentralize powers and Indianize administration. introducing some practices like first executive council, next legislative council, next bicameral legislature, next portfolio system, ordinances, portfolio system, ordinances, next three lists within that next point, three lists as federal, concurrent and provinces. Such practices became part and parcel of Indian polity, after independence, which can be considered as British legacy, So that is what we can talk. This is how we finish that aspects. Then let's basics already you know that if you did, so even more than that you will know about constitution. So when we talk about Indian constitution, Cabinet Mission Plan, there were several plans which failed, including Wawel Plan, if you study in your history. Ultimately, Cabinet Mission Plan was accepted because this mission offered complete independence. The leaders were not in a position to accept anything that is less than independence. So that is how the Cabinet Mission Plan provided this promise for complete independence. And that is how Constituent Assembly was constituted and it drafted the Constitution. So let's take about Constituent Assembly. So members were indirectly elected. They were indirectly elected, largely from provinces, nominated from princely states. Plus it's mated proportional representation. By means of single transferable vote. This the candidates, let's say that we saw divided on this, let's say Sikh, Muslims, and general. So the areas, the provinces where Muslims, let's say that had representation. In those provinces, the members, Muslim members, elected Muslim members for assembly, and similarly Sikh, they elected Sikh members. So they try to bring representation of that time majority means the other community also. At the same time, it was general rather than majority community. So to take care of representativeness, so that the members of Constituent Assembly are representative of our, let's say, the population, that approach was followed. So indirect election means provinces, the way nowadays Rajya Sabha members are elected, that method was followed. That time in election of the members of Constituent Assembly. Then once, let's say that the members are elected, then members should be also presided, let's say that, presiding officer. So presiding officer was Rajendra Prasad. He was elected as, this is how you find out, Rajendra Prasad. Before that, there were two members. So let's say initially they were elected, but they just remained provisional. It was Rajendra Prasad when meeting was held, so he was elected as President of Constituent Assembly. This Constituent Assembly was it performed two roles. One that is called, you can say, dual role. One is framing Constitution, and another legislative role. Yes. When it was framing Constitution, that is called constituent role. Basically, let's say when it was constituted, let's say 1946. To will find that or let's say its role was only constituent because we did not have complete independence officially. Still, we were a dominion state. When we were a dominion state, still it was not empowered to frame any law. Yes. Hence, between 1946 or 9 December, if you say 9 December 1946 to this August 1947, Constituent Assembly role was to discuss, deliberate on Constitution. This. That is how it played. Now, when we got independence, so till this time also it is not considered as a complete sovereign body. Constituent Assembly is also not considered as a completely sovereign body because we did not officially, let's say, they promised for independence, but officially we did not have independence. The Constituent Assembly was constituted when India was not yet a sovereign country. This, although unofficially we were a sovereign country, but officially we were not a sovereign country. This. And that is how a criticism of Constituent Assembly is it was not a sovereign body, which we'll talk after. Now, thereafter we'll find this. From 47 onwards we'll find this. From 47 onwards to when Constitution was adopted, this. So, we had November 26, November 26, 1949. This is how we'll know that. So, November 46, 1949. This is what we'll find. So, till that time, let's say that it was also playing the role. After independence to this, let's say, it was playing the role of framing Constitution and it was a body, let's say, considered. It was considered as a body like a sovereign body and Constitution was adopted. This is how Constitution is adopted. And from this to, let's say, January 26, 1950. This. Between this, let's say that it played also a role of legislature that we have written. Yes. It played also a role of legislature. And when it was playing the role of legislature, then it was presided by G.V. Maulanke. And when it was presiding to frame Constitution, it was headed by Dr. Rajendra Prasad. Means at initially its role was only to frame Constitution and hence its head was Rajendra Prasad. But once Constitution is adopted, then Assembly is still there to work as a provisional, let's say that role of playing the role of legislature. And when it is playing the role of legislature, so that time it is presided by G.V. Maulanke. And when it is working as to write Constitution, draft Constitution related, it is being presided by Rajendra Prasad, that kind of thing. And finally, let's say that the Assembly went on electing. The first president was also elected by Constituent Assembly. So Rajendra Prasad was also elected as first president because elected parliament was formed in 1951-52. Elections were held in 1951-52. So it went on also electing president. This, and you should know that after January 26, 1950, its role as constituent came to end. Because Constitution was framed, Constitution came into effect. So its role as a constituent body came to an end, and thereafter it played the role of provisional parliament. So what we are trying to say about Constituent Assembly? Constituent Assembly was constituted mainly to write a constitution. Now, why we use the term constituent? Constituent means a power given to write constitution, amend constitution. This is should know. So, Constituent Assembly you should know. So, it was, let's say, given power to write a constitution, adopt constitution. When it is, let's say, that holding its meeting and there is a process, in the process, let's say, it also starts playing the role of legislature, playing the role of law making, because we got independence. So when we got independence, and interim government was also formed. When interim government is formed, we got independence. Then government will have to make some laws. That's why national anthem, national flag, these things were adopted by the Constituent Assembly. And it went on also electing the first president, and let's say that thereafter 26 January 1950 to 1951-52, it worked as a provisional parliament. This you should know. Although our focus is not on that aspect. So, it is an indirectly elected institution, this you can say. It has taken care of representation of different sections, especially that time Muslims and Sikhs. That aspect can be considered, and Rajendra Prasad was considered its presiding head. But when it worked as legislature, so G.V. Maulankar was head of Constituent Assembly. Constituent Assembly comes to an end. Thereafter, it works only as a provisional parliament. Yes, that is how we should understand. Now, Constituent Assembly went on forming, let's say, committees. It had, let's say, committees, which you should read from the books. Committees, which we can say as major committee, and we say as minor committees. And among them, the most important was drafting committee, which was headed by B.R. Ambedkar. Now, you should know that some major committee you should know for your prelims. It is relevant for prelims. You should know that which committees were headed by Jawaharlal Nehru also headed, Sardar Patel also headed. There were committees headed by some leaders. You should know that which committee was headed. Similarly, let's say drafting committee you should know, and its composition also you should know for prelims. Composition, the members, let's say that. So, in drafting committee, there was also a member from Muslim League. You should know that. So, there is another, let's say, aspect that when Constituent Assembly was formed, that time India was not yet divided. So, the Constituent Assembly was a combined assembly for undivided India. But when partition happened, so then the members also got divided. In fact, Muslim League did not attend the meetings of Constituent Assembly, even if it was formed on the basis of undivided India. because they have their own, let's say, reservations, etc. We can say. And after partition means after independence, the members reduce this. These are basic factuals, not as important, but you should read from the books given. And it is the drafting committee which finally drafted the constitution that was adopted. Now, constitution has, let's say, that two things. One, adoption, and second is effects. This. So, adoption date is, as we have told it, November 26, 1940. It comes into effect on January 19. Although some provisions also came into effect on 26 November itself, when it was adopted. Right. But again, let's say that some provisions came, not all. So it would not be considered as effect. Effects, it comes when it is, let's say that brought by a particular date. The 26th January 1950 was chosen simply because of, let's say, 1930, when complete independence Lahore session, it was observed on 26th January. That's why 26th January becomes the date, let's say, and that is how constitution come into force. In fact, we have, let's say that, a system even in law making. When a law is made by parliament and president gives sanction, when president gives sanction, law is adopted. But it does not come into effect unless government notifies. So, law is, let's say, bill is passed, president gives sanction, then law is adopted. It has become a law, but it does not come into effect unless government gives notification in its Gazetteer of India. That is the difference. Same thing here, let's say that. Adopted. Significance is that a date has been followed, so we have a date to adopt constitution, and it has been adopted in the name of people. We give to ourselves. This is how the sentence. We give to ourselves this constitution. When we say we give to ourselves this constitution, so it has been adopted in the name of people. It means the people can change this constitution. When it has been adopted in the name of people, so people can change it also. That is how it's, let's say, significant. This is how we should know about Constituent Assembly and framing of constitution. Now, let's, the sources of constitution, if you see. Sources of constitution. So it depends how we talk. Once we told that way also we can take. We have told about historical, philosophical, this borrowing from others' constitution. This, and we told the spirit of freedom struggle, movement. They are the four major sources. Then, if you talk about borrowings, right, borrowings. So there is a classification of borrowing, which, let's say that it is called structural, philosophical, and political. And then others. This is how the question once it was asked. Structural and philosophical, they mention in the question like say this. So, if you take a structural aspect of borrowing, so it is related to Government of India Act 1935. Yes. That is how it has significance. The structural part of the Constitution, details of the administrative machineries, and Schedule 7, Union State and concurrent list, they are considered as structural aspect of the Constitution because it, let's say, establishes three-tier structure or two-tier structure of the polity. So this philosophical, it is mentioned as, let's say here, in this context, they mention related to US and let's say that Ireland. It is about DPSPs. It is about fundamental rights. This the most important aspect. Political is related to UK. This the system of parliamentary democracy. The system of parliamentary democracy. Plus others, let's say you can see the list. In Lakshmikant, you can say country-wise. Country-wise, you can see this. Which here and there will tell you while teaching some topics. Like say when we teach fundamental rights, DPSP, duties, fundamental duties, when we take federal polity, so there we mention the things, how, where you have incorporated. So we will not tell at one place, although you can read in books, but while teaching different topics, they will come. Like say when we say federal polity, cooperative federal polity. Cooperative federal polity comes from Australian Constitution. So we'll keep mentioning time to time while taking the topics. But yes, you should remember for your prelims some sources. Yes. Largely you know that this they repeat time and again, this Irish Constitution, DPSPs. So they keep asking this question, which is very simple. This, but in prelims in recent time we'll find that they keep repeating this. So that way we can consider political, philosophical, structural. In fact, if you take any three major influence on Constitution, the three major influence can be related to this 1935, then US, and then UK. Broadly, our Constitution, our polity is influenced by three major factors: 1935, US, and UK. US has major influence. First, the idea of written constitution, idea of rigid constitution. This you can say. So that aspect, fundamental rights, independent judiciary, separation of powers. No, this. So judicial review. Independence power, independence with independent judiciary means power of judicial review also. So it will be from US. Independent judiciary with power of judicial review. Anyhow, so this will come, let's say, later on. Why we are saying that? Because our entire parliamentary democracy is based on UK, although we have not followed UK in complete sense. And let's say that US also we have not followed in complete sense. Yes, that way we can see this. So these are some sources of constitution when we write. And then finally, let's say that key features, let's say that some salient features. When our constitution was adopted, that time we had second lengthiest constitution. The lengthiest constitution was by Yugoslavia. But once Yugoslavia disintegrated, then we became first. Our constitution is a lengthiest constitution. In terms of number of articles, its parts and schedules will find this. So it is the biggest constitution for biggest democracy, you can say this. Then we'll talk also to why it is lengthy, that will come later on. Other features, let's say that well known, a blend of both rigidity and flexibility. That we'll talk when we'll take amendability on a topic. There we'll talk it. Single citizenship, you know that we have, which is also a feature, let's say, because Different constitutions provide different types of citizenship. Largely, most of the constitutions have citizenship single. US has a feature of dual citizenship. You can consider separation of power with independent judiciary. So we'll take one day when we'll talk separation of powers. This you can say. All these features will be somehow today or tomorrow discussed also. So no need to talk at one place, but yes, that is how the topics given. So this way you can consider. Then quasi-federal polity or federal polity we can consider. System of responsible government, that is called a parliamentary system of government. And then let's say three-tier structure, although originally it was not part of the three-tier structure, but there was provision for village panchayat. And then 73rd, 74th Amendment has made it a three-tier structure that way. And then it has avoided the extremes of both US and UK. That we can consider. So, what does it mean when we say that it avoids extremes of both US and UK like? So we have gone for which we will deal when we'll take parliamentary. When we'll talk about parliamentary democracy, there we'll talk about this. What does it mean? This avoiding the extremes. At this stage, simply you should know that in US, since it has gone for complete separation of powers, plus judiciary has been given power of due process of law. Since the US has due process of law concept, so judiciary gets immense power. In fact, judiciary is the most powerful organ among the three organs. This. So there is judicial supremacy. US has experienced judicial supremacy, which India has avoided. Now, if you take UK, so UK has parliamentary supremacy. Its parliament is considered sovereign, and parliament can make any law which judiciary cannot strike. So, UK has the most powerful parliament, and US has the most powerful judiciary. This, which create problems, you know that. So, because of that, India has avoided that extreme. In our country, we have constitutional supremacy. We have adopted a system of constitutional supremacy, and the three organs have to work as per the provisions of constitution. In our country, relatively, there is a balance. None of the organs, you know that, can be considered quite powerful. At times, executive becomes powerful. At times, judiciary becomes powerful. That way, let's see, we'll find this. And that is how we can consider. So later on, we'll cover it. Then the question is why it is a very lengthiest constitution. Right? There are some questions that we'll deal. Let's raise. So, first is So generally these are some basic questions. These are some basic questions which are asked at that level when Constitution was framed. You can also see some criticisms. If you read Lakshmikant or any book you follow related to Constitution, so it is written that some criticisms are also given. Right? Criticisms that it lacked representation, Hindu dominated, so let's say Constituent Assembly, lawyer's paradise, this is how I can say, the legal, that I can say, it is a carbon copy, this you can say, borrowed Constitution. So we will not tell those criticisms, you can read yourself, not later, just we'll try to address some questions related to that. So the question first is why lengthiest Constitution, or whether Constitution was too big to govern effectively. Can we say this? No. So how we'll know it is a lengthiest Constitution or a lengthy Constitution? How we'll know it? So then we have to know, let's see some other countries, let's see how they have Constitution. Largely, if you see other countries, they have a small legal document in the name of Constitution. This there, let's say they mention some only broad aspects. Right? Like say if you take, let's say the US Constitution, if you take Japan Constitution, so they will just enumerate some broad aspects, not detailed aspects. Right? Like US has mentioned only that what government should not do. Then it is said what government should not do. But as we told yesterday, they had a colonial past. They wanted that they should bar the government from doing something which is not in the interest of citizens. This. So that way we can consider that they have written like this. And it is a very small document we can consider. But if you take India, let's say that, so we had that time, when we constitution was adopted, it was a huge constitution. No, we had total number of articles like 395. No. So that time we had 395 articles. 395, it is very huge, consider. So plus several parts and schedules you can consider. So the question is that why? Our constitution has not only this, you can say that, it also has what government should do. What government should do. Or, let's say that, factors influencing. This first is called transitional society. Second is called diverse society. Diversity. Extreme level of diversity in society. This relatively, if you take other countries, European countries, US, they may not be very diverse. As per there, they may have some diversity, but ours is a society which is highly diverse. North, south, west, east. This you can say tribal people that you can consider. Then rich, poor, backward. You'll find this. It's a huge society, and with that extreme level of diversity, you can say plus it is a transitional society. Largely, their constitution was formed when society has achieved a relative stability, or the developments in their society did not depend on the role of state. Developments in their society came through market and industrial revolution. This is to know. So they framed the constitution. So when they framed the constitution, that time they did not envision the role of the state to bring development. But when we are framing constitution, we are envisioning the role of the state to bring development. So development means the society has achieved relative stability. As we told you yesterday, change coming themselves and change coming through institutionalization. So we have to bring change through institutionalization. They have to bring change through, let's say that themselves. The transitional society means it will increase the role of the state. And when it will increase the role of the state, so it will have also, let's say, the role of machineries of the state. You have to mention different machineries in that constitution that we can consider. So this is how transitional society, extreme, let's say that. Then let's say that detailed enumeration. Detailed enumeration about machineries of government. Yes. So we are not only mentioning ours is a country, let's say that. I will come back to this. Ours is a country, let's say, constitution, if you see. So it does not mention only about 3 organs. This detailed machineries, this you can see this also. Relations between president and government, governor and chief minister, that you can find. Others will not give, let's say, clause by clause, let's say, detailed relationships. Then we can have, let's say, CAG, UPSC, Election Commission of India. Then we can have Scheduled Caste Commission, Scheduled Tribe Commission, blah blah things will find. Finance Commission plus Civil Services. You should know that countries will not necessarily mention them in their constitution. They will not necessarily mention in their constitution. This. It is Finance Commission, Scheduled Caste Commission, Scheduled Tribe Commission. This. Election Commission of India, UPSC, CAG, you know this. Then Civil Services, let's say administration. You should know that in US, in its constitution, even the term administration has not been mentioned. Yes. Term administration has not been mentioned. But in our constitution, forget about administration. We have detailed provisions related to even civil services. No country in its constitution mentioned about civil services. India is the country which mentions about civil services. This. So you can see from Article 309 to 312, then UPSC Article 315 to 323. Yes. Similarly, CAG, you can see that 148 to 151, Election Commission of India, you can see this. So these are, let's say, detailed enumerations. You do not only mention a particular institution, you mention its role, functions, you mention its powers, you mention its reports. So for submission of a report, there is a separate article. Yes. This is how we mean by detailed enumerations. Other countries will not mention details of their machineries, rather they will be regulated by the law of the legislature. This. So because of that, transitional society. So let's take that transitional society as we have mentioned. Even for transitional society, you know that there can be different as is society also. So when we have a transitional society, you know that many provisions are related to scheduled caste, scheduled tribe, etc., etc. This. So you can have Article 29, 30, right, for cultural, etc. rights, isn't it? Then for, let's say, 371 onwards, for various special provisions, let's say A, B, C. Then we have Schedule 5, Schedule 6, etc. You will find this. So for society also you will find this we have. Then even fundamental rights, you can say Article 15, 16, 17. They are related to societal, transitional society. It's this untouchability practice, so you have to abolish it. Social justice by 15, 16. So that is how transitional society also. So it becomes lengthy because of our society. This not because that we wanted to make it lengthy. This. So then question comes, then there's some other factors also will talk. So it's about transitional, extremely, let's say, detailed enumeration about the government. This. Then learning from others. Others' constitution. We introduce some safeguards, let's say that. There will be some safeguards because those things should not happen in our country. So you will include some of the provisions. This. So these things, let's say that you consider what we have seen. Then we can add this point also. What government should do, that also. This. So these things can be considered some factors. Now let's say the question is, can we say it is too lengthy to govern effectively? Yes. Can we say it is too lengthy? Borrowed case, sorry. So then you have to go about working of constitution, how it has worked. Right. It depends on working of constitution. And by and large, it says that it has worked better. It has worked better. Hence, those who say that it was a lengthy constitution and it will not work, they have been proven wrong. This you should know that. Because our constitution has worked. And the West can wonder how it had, right? Because they gave a death sentence to the constitution, sorry to say that. This constitution was not going to work, as it is highly lengthy and cumbersome. But it has worked. This, in defense, this is how we can write. Although let's keep, we will tell you when we'll tell about working of constitution after this. So there I can tell you a bit while dictating this. That we can consider. Now let's come to this point. Is it a borrowed constitution? It is yes. Then it lacks originality. Then what you will say on this? Right. what you will say? Yes, it is a borrowed constitution. There is no problem in admitting it. Right. Mhm. So it lacks originality. This, yes, also it lacks originality. Right. But how to defend it? The first thing is that can we say that anything that lacks originality is a problem? Right. Not necessarily. This This is how B.R. Ambedkar says. So B.R. Ambedkar says that no one can have patent on originality of constitution. Right. You cannot say that it is your constitution. So you cannot have a patent on that whether it is the original constitution, it is not a original constitution. This first thing is that. Second thing is that when you are writing a constitution in 1950s, and you are not learning from the working of constitution, so that also will be considered foolish, isn't it? And if you are writing a constitution and you are not incorporating some best practices, that also we consider foolish, isn't it? So when any country writes constitution today, even Nepal just adopted a constitution. When Nepal adopts a constitution, so, and can you criticize that it is not original constitution? How it can be original? When you write today, it should not be a criticism at all. Because anything you write in the constitution, you'll find it was first followed there, it was first followed there. Isn't it? Only US can have. US can have this Lecture-3 aspect. It can say its constitution has original. Because it was first written constitution. But again, it cannot still be considered original. The content in the constitution may not necessarily be US. The content in the constitution may not necessarily be US. Because written constitution can be new. But the content that we have written in that, you cannot say it is new and it is for just, it belongs to US. This, even that also, because knowledge has always evolved. Right. Let's say simple, if you take English dictionary you take, English words you take. English words are not English words. They cannot tell that those English words are theirs. उसमें संस्कृत के भी word है. There you will find also words of Sanskrit also, Arabic also, Latin also. But we say that it is English. The words roots can be derived from a Sanskrit also. This. So we cannot tell that it is original. Means we should not criticize it at all that it lacks originality. Right. Rather we say whether it is relevant or not. B.R. Ambedkar went on saying that this is how you cannot have patent right, means no one can have patent right on originality of constitution. First. Second, they have not been simply incorporated, means blindly incorporated. Rather, he says there is ransacking, the term he uses, right? There is a ransacking of all those world constitutions to know their strengths and weaknesses, to know how they work and how they fail, to learn from failure and incorporate their best practices. So those best practices have been incorporated in our constitution as per the suitability of our conditions rather than blindly imitating them. And hence, it should not be a question at all that it is a borrowed constitution or a carbon copy, let's say. Someone has criticized that it is a carbon copy of 1935 Act. But it can be a carbon copy, let's say. But that 1935 Act was also drafted by the British Parliament for India. The only thing is that it was drafted by British Parliament, but they were drafting for India, not for UK. And UK was a unitary state and they were promising us a federal polity. Try to understand this. UK is a unitary state and they are creating India as a federal polity. It is also that they are not trying to impose their polity on us. If they had to impose their polity, they could have gone with unitary state, not a federal polity. And federal polity is a system of US. So that way also we can say this. So that is what, let's say, even 1935, it was, but it was relevant for our country. It gives details of the machineries of the government in terms of subject division, and those subject divisions still we continue, which are relevant. And therefore, even if it was drafted during British time, but we cannot say that it is just a merely extension or a carbon copy. Rather, those provisions are relevant and those provisions from other constitutions have been borrowed so that we can learn and improve our own constitution. That is how we can write in difference. So this you can write, so let's write on this. Right. It can be accepted. It can be accepted that Indian Constitution is borrowed. Indian Constitution is borrowed and it lacks originality. However, B.R. Ambedkar went on defending first act of borrowing, and second, lack of originality. That second paragraph, then you write that no any country can have patent right to any constitution or originality of provisions of constitution. Second, thereafter, the borrowings from different constitutions were not merely imitation, rather there was ransacking of most of the constitutions of that time. First, to learn from their failures. And second, to incorporate best practices. He even defended even defended the incorporation of Government of India Act. He even defended the incorporation of Government of India Act 1935, 1935, as there were sharp criticisms. There were sharp criticisms. Criticisms like first, Indian Constitution was merely an extension of Government of India Act 1935. Government of India Act 1935. Second, it was a carbon copy. It was a carbon copy. Second paragraph. He was of the view that the provisions of 1935 were relevant for Indian polity, and that's why they were incorporated. Hence, borrowing per se should not be considered as a problem. Borrowing per se, P-E-R-S-E. Borrowing per se should not be considered as a problem. Rather, what has been borrowed and how has been borrowed, should be factors deciding relevance of the Constitution. So that is what we can talk about borrowed aspect. Right? How you borrow, what you borrow. That should be the matter rather than merely let's say it is a borrowed Constitution. And that should be the matter that we should think about. That is how we can say on this. The 35 wala also we have dealt. This the factor that we were talking. Now let's take, is it more flexible than rigid? No. So generally a question can be, we expect a question, although we'll deal when we'll take amendability. Since we have not talked here, we do not teach amendability. But since we have 100 plus amendment, this then it shows that flexibility. It shows that it is flexible. Next question is generally asked whether they show relevance of Constitution or have made irrelevant. So we expect a question on this that way. Since constitution related question we will not deal when we'll talk amendability, we will deal only their flexibility and rigidity by comparing with US. Constitution related question will deal here, and provisions related whether it is flexible, rigid, how, so we'll talk when we'll talk amendability when we'll take fundamental rights. So flexible to clear hai it is flexible. How we'll know again it is flexible? Right. So you can see the role model US, right? So 27, yes, 27 amendments have been done. Let me tell Japan how much they have done, how many times they have amended. Total number is not showing the split. They have also less number of amendments. Anyhow, so India we have 100 plus. So in this comparison, it is flexible. That's also let's say there 1789 to present. How many years? Right. Almost 2.5, more than 2.5 centuries, isn't it? And it is only 70 years. In this comparison, it can be considered flexible? No. So by this we can say it is flexible. Yes. Yes. Then question is not there कि it is flexible or is that तो बहुत ही basic question हो जाएगा 2013 से पहले का question है उस समय ऐसे question आते थे अब तो ऐसे question आएंगे नहीं अब आएगा relevance why such amendments why so many amendments we have done and if we have done so many amendments so then let's say that ki, whether they make constitution relevant or let's say that ki, they distort constitution. So if you do 100 amendments, so many a time let's say the original intent of the constitution can also be changed. No. That aspect. So let's say factors for frequent amendments. Why we have more amendments? No. The factors will be related to this. Yes. You take it A, we'll write there. Plus this also, but largely it will do this. Why have more amendments? It is a transitional society. No, it is a transitional society, diverse society. Detailed enumerations we have written details, so that will result into amendment. जब उन्होंने mention ही नहीं किया है तो amendment क्या करना है? When they have not mentioned detailed provisions, so whatever the changes they would bring, that should be outside the constitution. And when we have mentioned so many things in the constitution, if you bring, so then there would be multiple changes. This, that is how it results into amendments. This, so that way you can consider this. So, factor A you can say. Second is then organic constitution. Constitution is considered an organic document. This, not, let's say that, inorganic document. Organic means it is a dynamic, let's say, it can be changed. This, that you can consider. And then let's say that is suitability. Let's say changes in society. Changes in society. These things result. Even let's say that Nehru remarked, if you see there are several remarks, so Nehru remarked that it is an organic document. And we expect that there's, let's say, it should remain flexible so that it remains relevant to its time. So relevance to its time means, let's say, whatever the society we have as of now. So amendments bring relevance of constitution. It makes constitution more relevant to its time. This you can say. But at the same time, they will try to also distort. So why we have done amendments? So these are the factors. Since we are a transitional society, US is a developed society. So it is a stable society. A stable society needs less change. Ours is a transitional society. So that we can consider. Plus, yes, one legal provision is that it is or amendability, amending process is flexible. And amending process in US is it? Try to understand. Their society is stable. So they should have flexible constitution. But stable society also and rigid constitution also. And we have, let's say that transitional society and flexible. So very easily it can be amended. In fact, the amendment by first procedure is no amendment at all. There are three types of amendments. Special simple majority. Then you have special majority and special method. Procedure, that is how I say that. Amendment by simple majority is presumed that it has been amended without bringing any change in the constitution. Isn't it? It is just, let's say, creation of states. The creation of states, it does not bring any change in constitution. It is presumed that it has been amended. Thus, that is how we can say flexibility. So, process of amendment is also flexible if we see US method, because US method is very rigid. That can be also a factor in having so many amendments. This you can say. Like say that you know that reservation. Reservation is given to scheduled caste and scheduled tribe. It was told that after 10 years we should review it and we should discontinue if, let's say, aims are achieved. But what we do every 10 years, we amend it and extend it. 70 years, 7 amendments. ऐसे ही सिर्फ हुआ, सिर्फ किया, extend करना. Similarly, Hindi language. Hey, the same thing related to Hindi language. Again, we keep extending it. There could be several such provisions you can find. And that is how we can say related to this. But its con side is Pro side is it makes Indian Constitution more relevant, organic, and that is how it helps in governance. It remains suitable to its time, people. But the con side is it can result into distortion. No. Con side, let's say. Basically, the most important concern is by this. It is distortion. Distortion, let's say that. Then it took away power of so some provisions, let's say. Although we'll deal in fundamental rights, you should know that the US Parliament, the Congress, cannot take away fundamental rights of citizens. Whatever they have mentioned in their fundamental rights, you cannot amend it, you cannot change it. Especially you cannot take away that because they are absolute. But ours is a country where we take away right to property. Right to property is considered an important right in case of fundamental rights because it is related to your life. This you should know, which we'll talk when we take right to property. Since ours is a transitional society, we wanted reforms, land reforms, agrarian reforms. These things, let's say that became basis for bringing change, First Amendment, then 44th Amendment. The 44th Amendment took away that right to property. This. So this you can say like, let's say this. It was a complete review of Constitution. It was a sort of complete review of Constitution. This. And its distortions have still not been completely eradicated. This is how it is said. It took away judicial review from many provisions and it made entire DPSP's president over fundamental rights. The con side is that amendment can even, let's say, destroy, you can say, or affect, you can say, distort, you can say, the original intent of premise of Constitution. When they incorporated right to property, so whether they had intention that one day it would be removed, and whether they were not aware about transitional nature of society, whether they were not aware about right to property of people when we have to bring agrarian reforms. This, that is how we can see this. And yes, as you were saying, just after independence, First Amendment, it's just after adoption of Constitution, the First Amendment was carried out to bring agrarian reforms, land reforms, Schedule 9 and etc. etc. Yes. So there are both aspects. Amendments have made Constitution relevant, and they have also resulted into expansion of rights of people. This, like say, if you see this, it is reducing. We have added also right to education. We have added Article 21A, right to education. This you can consider. If you talk especially about fundamental rights. In that way, we have added many other rights. Let's say we have given legal rights, right to information. So, citizens have been given, but at the same time, it has taken away. And at times, it has happened that amendments have tried to even destroy the original intent of the Constitution. That is how on the con side. But on the whole, we will say that amendments have made the Indian Constitution more workable, right? Rather than making it and keeping it as rigid as in case of others' Constitution. Yes. This, that is how we told that it is transitional society. If you want to have more level playing field in society, egalitarian society, you can say that. And government needs flexibility. No, no, no. That's ऐसे नहीं होता है क्योंकि अभी we have not taught you all those things. Here we are trying to take a general view. This, and in that general view, we are taking the big pictures. Let's say those were major things which have happened. But when you will learn gradually, let's say, what we have done is we give fundamental rights with one hand and take away with another hand. You may have heard about this, right? तो लेट्स से दैट कि आपने आर्टिकल 19 लिखा, आर्टिकल 19, बट आपने क्या किया, इसमें आपने सबको राइट्स दे दिया और 2 में सारा रिस्ट्रिक्शन लगा दिया. बस ऐसा यूएस में नहीं होता है. बस, और ये सारे बाद में आपने ऐड किया है. लेट्स से that is called sedition, defamation, public morality, decency, security, all these things, the clauses that we have added, when we teach this, you learn it. Now the question is that why you should be reasonable? ये होना चाहिए reasonable. But लोग क्या समझते हैं? 50-50. स्टेट भी आपको ऐसे ही समझाता है 50-50. Yes. But no, it's not 50-50. Reasonable restriction means, let's say that it should be when it is needed. My right has my primacy. But governments, in the name of blah blah things, you know that they restrict and they say there can be reasonable restriction. How can there be reasonable restriction? Right. So then it is about there should be a balance. Students भी लिखते हैं. There should be a balance between freedom of expression and stability and how it's fundamental rights are not about balance. It is about imbalance because rights are more than let's say, rights of state. Individual rights are more important than rights of state. This is similar. But again, let's say, time will come, you'll understand this. But as far as property rights are concerned, yes, somehow let's say it's not anything written in the constitution. Then it becomes like we cannot change it. Our premise of the constitution who are not fallible people. Right? They may also have, like as we tell that they did not have experience of working of a government. Problem unke saath, that is how we will keep saying later on also. The framers did not have the working, they were not having any government experience. Right. So somehow a constitution can have some ideal aspect, ideal element. This is also a criticism. Right. Is constitution ideal? By this it came in mind, so we'll add, so that in the end I will tell you this. Here it is Western. That is also a criticism. Whether constitution is ideal, basically it incorporates the ideal liberal values of Western society, which does not suit to Indian society. This, should we adopt or we should change? That is also a question. Anyhow, so we were talking on this. So con side you can write a bit, then we'll take next. Let's see. Indian Constitution in comparison to US Constitution is a flexible constitution. There are more than 100 amendments. Which show that it is flexible, as US has 27 amendments. Due to high number of amendments, there is a view that the original intent of framers of the Constitution has been distorted. For instance, there are some amendments like 42nd, 44th, which took away some rights of citizens. Like right to property. It's by other amendments, restrictions have been imposed on the rights of people. Therefore, It is criticized that amendments have distorted Constitution. Amendments have distorted Constitution. However, even the framers of Constitution did not intend the continuity of the same Constitution. Nehru remarked that Constitution was an organic document. Constitution was an organic document and it should remain relevant to its time. Therefore, conclusively it can be stated that the amendments have made Constitution more relevant. Rather than bringing distortion. This now let's say that this question. Can we say that it is lacking sounding? It lacked sounding. Constituent Assembly. How will defend it? No. So, since Constituent Assembly was constituted, it is because of that we say it lacks sovereignty. How can we defend what we can defend? Popular members. So anyway, they did not try to control, they did not try to interfere in the affairs of the Constituent Assembly. They were completely independent to decide their business and incorporate any such provisions. UK did not try to interfere or even indirectly also influence to incorporate this provision or that provision or this kind of system or that kind of system. They no way they tried it, they completely dissociated and they ensure this is how the independence of the Constituent Assembly. There is no any report, any fact, any, let's say there's a book which can say that they were trying to influence to adopt UK type of practice or this kind of practice. So even if it was a dominion status having, but still let's say it was a sovereign body, an independent body, that way it can be defended. 4 or 5 years back, one article was written in the Hindu. If you Google it, you can get that article. That article was very, at times, odd types of articles are written, you know that. That article was written that since Constituent Assembly was not a sovereign body, hence India should form a new Constituent Assembly to adopt a new constitution. That is all famous. So, very odd type of article. This at least there is a, let's say, perception in society. Some people still hold that perception. It was not a sovereign body, so we should have our own sovereign members now and they should write a constitution. Isn't it? So that way we can consider this. And finally, let's deal with that law, that liberal constitution, ideal constitution. recent issues you can find, especially gay rights. The gay rights, if you talk recent one, the government has told to the court that it does not suit to Indian society. Yes. So even if Supreme Court has been trying since 2009, you know that, but the Supreme Court struggles. And Attorney General goes on, basically Solicitor General goes on giving lots of logics before a constitution bench, right? And constitution bench ये सोचता होगा कि क्या है सब बिना मतलब का लॉजिक दे रहा है, but वो बोल नहीं सकते. Matter is very simple, right? Yes. If you see videos nowadays of the hearings, isn't it? So this is how a Solicitor General, Tushar Mehta, he keeps giving one after another logics to convince the court. This. So that way we'll find this. But it's a matter of, let's say, if you talk liberal rights, means liberty means this is how, freedom means people have equal rights. And it has one principle, if you are adult, so you can take decision about your own, let's say that body, this, or about your own life. This is how liberal right. This is what you can say. That is how, let's say. So these are Western concepts, let's say. Similarly, when we'll teach you secularism, there also we'll talk. So you can see that Yogi ji has once spoken in one speech. ये वेस्टर्न वैल्यू है, इंडिया सेकुलरिज्म को नहीं मानता. बस तो हम मानते हैं, वो मानते हैं, प्लूरलिज्म को मानते हैं. डिफरेंस क्या है दोनों में? प्लूरलिज्म में ये होता है कि एक कम्युनिटी को हायर राइट्स दिया जाएगा, बाकी को भी राइट्स दिया जाएगा, बट वो राइट्स नहीं दिया जाएगा. एक कल्चर को सुपीरियर राइट्स दिया जाता है. जैसे पार्लियामेंट का इनॉग्रेशन हुआ तो वो हिंदू कल्चर के अकॉर्डिंग हुआ, और बाकी लोगों को भी बुलाया गया था, ठीक है, साइड में खड़े रहने के लिए. सॉरी टू से दैट. तो बेसिकली sarcastically let's take it, although it is the third class, let's say, but I have habit of speaking in a sarcastic manner. So that way you take that. Basically, inauguration happens with the entire Indian culture, majority Indian culture, Hindu culture. But parliament is a neutral entity. This you should know that. The Hindu culture and पूजा वगैरह सब होता है, और थोड़ा सा उसको सेकुलर बनाने के लिए बाकी के रिलीजन्स के भी लोगों को लाया गया था. उनको बोला गया था कि साइड में खड़ा रहो, जब तुम्हारा नंबर आएगा तो एक एक करके बोलना. So this way you can find this is plural society. It is not secular. It is manifestation of plural society, in which one will have domination, other would have their presence. Yes. Anyhow, no, we'll come to. Let's. Here ये time नहीं है. When we'll take secular topic, secularism, there we'll talk these things. यहाँ पे no need to go in details. Right? Otherwise we'll get deviated on this aspect. So that let's say similarly women rights, you know that सबरीमाला, जब सुप्रीम कोर्ट ने जजमेंट दे दिया है तो मान जाते हैं. उसके बाद मान जाते हैं कि चलो ठीक है, great. The सबरीमाला judgment comes. And then government does not implement the judgment. But it is the duty of the government, once court has given a judgment, so it is going to execute it. But rather it side with protesters. And then there is a review petition. Other things happen. So, and there also, let's say, it is a conflict between constitutional morality and social morality, which UPSC has asked 3 times. 2 times in ethics paper, once in polity paper. Yes. So again, it is constitutional morality is Western concept, and social morality is related to society. Yes. They are also not accepted. Women right related to military also. Higher level, the government told to the court, no, there is resistance from military. But court went against government and gave, let's say, rights to women in commissioned forces, in defense forces. Like. So that way you can find, if you find this, so Western aspect we say conservative society. Similarly, let's say live in, this we have told that. Live in, let's say, is a Western concept. People let's say that individuals when they are grown up, let's say 12 years plus, 14 years plus, whatever the age factor can be, 18 years plus you can say that. Or marriage age, let's say that. They can live together even if they are not married. That is how we say live in concept. But it is being considered as in conflict with Indian culture, which believes in marriage as an institution. Yes. So that is how we'll find this. So society we can consider a kind of this, why it is considered. So constitution, liberal aspect will find, and society we can say, how society is this, and constitution is this. That is a huge gap. No, should we adopt a Western liberal constitution? That this is how it is. Or a new polity and old administration, that is how we say it. So we'll deal when we'll take parliament also, when we take judiciary also, and when we'll take role of administration called civil services also. Again we'll talk this. Try to understand that. Today perspective is different. Why it is different? Because a party which has come to power, that time this party voices were not heard. During freedom struggle movement, during framing of constitution, and for almost 60 years of our independence. This party remained marginalized. Its ideology also remained marginalized. This is true. But gradually, let's say that ideology has grown up to an extent that it has got even mandate to form government to govern. When it has got mandate to form government and govern, so it is government. When it is government, it will try to implement the ideology for which it was seeking mandate. This. And that ideology is more related to Indian culture. Indian culture, Indianization, this is how we find this. And that is how you can find that since the present government has come, you'll find even government activities also you can find that lots of religion comes. Lots of religious things you can find in government activities, which was not part of past governments. This. So that way we can consider this the influence. And that is how, let's say, now a debate has started that these things are Western, and we have started saying more and more on this. It is Western, and this Indian Western, this kind of debate once again. Like I told you that even nowadays students start writing, India is a temple of democracy. It is a, let's say that mother of all democracy. ऐसे लोगों का already mindset बन चुका है. Right. It shows that lack of understanding about the modern political developments. This, because somehow there is a cultural superiority. This, we should respect our culture, but we should not have superiority complex. Because then both things are two different things. This, anyhow, so this debate we adopted when the constitution was adopted. So the framers of the constitution were liberal. They may be socialist, but at the same time they are also liberal. Right? And that is how freedom struggle movement, the spirit of freedom struggle movement, you can understand that how they were liberal, that it is because of those leadership India still did not adopt country as a religious country, means it did not go on adopting India as a Hindu Rashtra, although it could easily do. It can easily do any time. Right. But it did not adopt as Hindu Rashtra. Partition happened. The other country created, let's say that adopted as, let's say Islam as religion, not a secular country. But we remained a secular country. This is criticized by some sections in our society. Right. You know why it did it? It was because of that division happened. But it is not like that. It happened because of this. Right. Rather, let's say that history, I will not go into the history. Secular, the leaders strongly defended secularism. They wanted to remain secular. That is how they have adopted a secular constitution. So it's not only, let's say that secularism they adopted, even constitution is also secular. Because it does not give any biasness to this or that community. It gives some special rights. Special rights are not biasness, let's say that. Biasness is one thing, special rights are another thing. This, like biasness can be that parents can have discrimination against the children, or parents can give a special attention. Giving special attention may not necessarily be biased. But what we have presumed or considered that special rights are biasness. कोई भी किसी भी वर्ल्ड में किसी भी कंट्री में ऐसा नहीं होगा कि यूनिफॉर्म राइट्स होगा. Right. So this we have to understand. They were Western means they were liberal. It's not Western. We can say they were liberal because most of the countries are influenced by liberal democracy and liberal values. You can say that. If you can criticize them, then why you are adopting market economy? It is also a Western. Globalization. And all these, let's say, globalization, liberalization, all these things. Why we are influenced by this? So we cannot think in that. We should not think in this way. West, East. Rather, as we were talking about borrowing, whether it is relevant for our country, whether it is suitable for our country, do we need it? This, that should be the aspect rather than talking Indian versus West or let's say this or that. Otherwise, already you know the Swadeshi movement failed. Right. You don't have to experiment again. We should give emphasis on whatever the culture we have, but at the same time our boundaries should not be closed for other cultures. That is how it is. Yes. Yes, it is futuristic. Yes, you can consider history is being rewritten, but that's very different thing. Although it is not a time to talk all those things here, but what we are trying to say is that yes, there is a perception, there is a section in our society. It is a view that Indian Constitution is highly liberal and Western, and since it does not suit to Indian society, hence it is an alien constitution. Right. And when it is anything that is alien, is not going to work in Indian condition. And therefore, some people can blame even constitution for failure of our society so far. If our society is not able to grow, not able to, let's say, develop, so it is also because we adopted an alien system of government and alien system of polity. That cannot give you. but it will be considered as a more regressive view rather than a progressive. This, because progressive view is that you should be open and inclusive. At the same time, we should continue also our culture. That is how it should take. That is how the view can be expressed. Just 2-3 lines will summarize all this. Let's write. As far as the question of Indian Constitution being liberal and Western is concerned and its criticism that it is an alien constitution. It is an alien constitution. At best, it can be considered a regressive view rather than a progressive one. Second paragraph. Liberal constitution does not mean rejection of tradition and culture. In fact, constitution itself goes on. Protecting language and culture. Its liberal aspects try to eliminate social evils and discriminatory practices. The framers of the Constitution were aware about such practices, and their perspective was to establish a modern and progressive society. Their perspective was to establish a modern and progressive society. Yes. The rest debates will continue. It's endless debate. No need to write all these things. You should know that. So, whether you want, let's say, what you want to. When we'll take other topics, other things will read, you will also understand yourself. But the question is that today it is difficult to decide, again, as we were saying, you cannot have a patent right what is original. So when this is a view, so we cannot say that this is Indian, this is Western, this is how no. Rather, yes, basically the idea is influence ki every country has, basically those countries, they have tried to continue their own culture. Yes. They have one, let's say, culture, let's say, and language they have, let's say, Japanese, it will have a Japanese language, Chinese, it has its own language. If you take Western countries, then you can say that they give preference to Christian religion. So that's why in India also, they think that we should also have a Hindu culture as main identity. And other cultures should also side by side exist. It's not that they are against them. But this is how it is somehow modeled on this kind of aspect. But then you have to understand that their culture, let's say Christian, There was only Christian religion. They did not have all sort of religion. Our society was never monologous type. Let's say it was having one religion. Rather in ancient time also you had Buddhism, Jainism. So even in ancient time there may not be Islam that time, but you had Buddhism and Jainism. And they fought for, let's say that, there were also conflicts. So it was never, let's say that, only, let's say, monological type, that only one religion. It remained diverse. So we cannot compare with them. This, anyhow, these are the developments, passing developments. By the way, let's say that we'll conclude on constitution part. Debates will continue. There are still several aspects to talk. There is a view that the constitution, let's, if you talk as constitution per se in general, so basically if you take constitution, and in that sense, so there is a view since it has become, let's say, 70 years. So then should we change? Should we continue with this? So many amendments have happened. So amendments etc. have resulted into making constitution further lengthy document. And some of the provisions have become irrelevant also. Yes. So we have some, let's say, provisions, let's say plus we have, but there is also minus reduction. Some provisions have become, let's say, irrelevant. On the whole, they have made the document more complex. Yes. When document becomes complex, it results into, it affects governance. Governance is affected. Basically, we have one foundation, Vivekananda Foundation. Vivekananda Foundation, which Subhash Kashyap is also a member of Vivekananda Foundation. It has published one article on this aspect. Since Constitution, we have over 70 years plus lots of amendments, then it has become cumbersome. And when it has become cumbersome, so we need to write it afresh. Right. Why? Because if it is complex, law is complex, so governance will also be complex. This, because today, you make any policy, then it is challenged in the court. Lots of conflicts it can have. This you can say. Plus, we'll teach in fundamental rights to know that so many judgments have been given that it becomes very difficult to link and streamline the judgments. There are some gaps also created because one particular section is nullified. The link between the preceding and succeeding section is somehow, let's say, that disturbed. This is how the complexity you should know that. So already there is also a perception on this aspect. Should we do that? But it is a very difficult exercise. Second thing, let's say, it is this perception that is resulted into constitution of National Commission to Review Working of Constitution. Right. We have a commission constituted known as National Commission to Review the Working of Constitution, headed by M.N. Venkat Chalaya, constituted during Vajpayee government. Yes. And it has reviewed the Constitution. This is, in a way, reinforcement of this perception. Yes. And we cannot write, but you can tell. Basically, the present government and RSS, so they have the thinking that, we should write a new constitution, basically. Gradually, means they are not trying, they do not want to tell all these things, but you know that if you think 30 years back, if you see RSS, and their activities, so they did not accept national flag, they did not accept national anthem, and they do not accept this constitution. Because they have reservation with some provisions of the constitution and reservation with green color in the national flag. This. So that is how we'll find this, let's say, if you see 30 years back, but they have changed themselves. They have changed themselves, this is how. So that can be one aspect. So this is how when this commission was set up, K.R. Narayanan gave a remark that time. K.R. Narayanan told that we have to see whether constitution has failed us or we have failed constitution. Yes. So that is how one aspect you can see. Basically, let's say there is only one country, you should know that. There is only one country, and that is called France, which has written constitution 5 times. This France is a country which has written constitution 5 times. Only example you have where a constitution is, it has its own legacy then. Right. It can change constitution, rewrite constitution. It does not bar also. When we say ki we give this constitution to people, this, so it is hand of people. People can decide. So there is no bar on that. Yes. That's why preamble, when it writes, on the day of 26 November 1949, we give it to people. Right. So constitution has been signed in the name of people. Right. So it means that people can, right, if they have signed, they can take over their sign. We can adopt, means we can have a new constitution. So these are, let's say, that idea. Just to summarize this idea on constitution, etc., just to tell it, we should go by Rajendra Prasad's statement and conclude on this. Otherwise, it remains endless. See, Rajendra Prasad, when constitution was framed, then he remarked that we may not have framed best constitution. It may have its own flaws and weaknesses. But even a weak constitution can be run better by men with virtuosity, by good people. Means a weak constitution can be run better by good people. And he say, I would pray to God to create such people in abundance. That is what he is saying. So, constitution can never be a perfect document. This you should know that. It can have this or that flaws. First. Second, if you frame today constitution, it will have more flaws than what the constitution will have. Because you need to have the men like members of Constituent Assembly. And we do not have that kind of men now. Because our minds are defined, our minds are distorted. This you can say. Because of this and that aspect. Whether you accept it, you do not accept it. Second, that even let's say there were members from Jan Sangh, this S C Mukherjee, Hrishikesh Mukherjee, others, but still they were given place in government. The broader aspect of the government. Even Nehru and Ambedkar, Gandhi and Ambedkar may have this tussle. They did not have, let's say, that consensus or let's say that same views on many things. But B.R. Ambedkar is made drafting committee chairperson. This is and they went beyond their personal things and they were progressive. Right. They went beyond personal thing and they were progressive on that. This is one thing. Although they could not also have consensus on several matters. Right, like say uniform civil code. They may not have, let's say, consensus. But at the same time, if you read Constitution as a neutral person, you'll find that it is difficult to write that Constitution now. So that's why the question that if today you adopt any Constitution, it will have more flaws. एक लॉ बनता है तो चैलेंज होता है और यू नो दैट कि कितने उसमें फ्लॉज होता है. You can easily identify flaws in those laws. This, and it is challenged and then it has to be nullified also. This, or it is not a strong law. This. So एक law में ये problem है. तो imagine the Constitution. That is how, let's say, we can give credit to them for the Constitution. And that is how it has become basis for whatever country we are today. So it is also, let's say, its credit goes to our Constitution. Because it has become the final document where the buck stops. Right? About the relationship between the three organs of the state. And sanctity has not yet been questioned. This is should know that. Its sanctity has not yet been questioned. There can be this or that view, but still nobody rejects Constitution. Yes. And that is how it's benefit. A few lines we can summarize, then finish it. Let's write all this. So, as far as Constitution as a legal document is concerned, as far as Constitution as a legal document is concerned, and several debates on this document related to first, whether it was a workable Constitution, Second, whether it has become a complex document, after more than 100 amendments, Right. Next, Constitution of a Commission to review Constitution, known as this National Commission to review working of Constitution. All such debates can be summarized. By two remarks. First, once K.R. Narayanan stated that we have to see whether we have failed Constitution or Constitution has failed us. We have failed Constitution or Constitution has failed us. Second, Dr. Rajendra Prasad, that we may not have framed the best Constitution best constitution, but even a weak constitution, even a weak constitution can be run better by good people, And I would pray to God, such people would be created in abundance. Such people would be created in abundance. So that is how we can talk. Our process of one aspect, one episode that is just beginning, let's say finishes here, related to historical underpinnings, evolution of constitution, its major characteristics that we can consider, debates. Today we focus on lots of debates related to constitution, which generally will help you broadening your understanding about the constitution, the document. Not necessarily that a question can be asked, or let's say that yes, there are some of the debates where there can be question and a potential question, you can say this. But it's all about understanding that document and all these debates, this you can say. And then next time we will take your preamble. So preamble, we take preamble, then we'll take fundamental rights. That is how we'll proceed. So again we'll tell, you read your NCERTs, no, to have basic understanding on this polity, and then you can read also preamble. Although there is nothing much technicality in preamble as per the books, let's say that. But as per the debates, the questions which have been asked, they are more contemporary in nature. Yes, so we'll take next time and finish it.